Good morning, everyone, and thank you for joining our webinar. The topic that we are going to be discussing today is the San Francisco Paid Parental Leave Ordinance, what employers need to know. My name is Rita Aguinaldo. I am the Northern California Outreach Manager for Small Business Majority, and I'm happy to be your moderator. This session is hosted by Small Business Majority in partnership with Legal Aid at Work and the City and County of San Francisco Office of Labor Enforcement. We're pleased to have experts from both organizations as our experts, our guest speakers today, to go over the nuts and bolts of the new San Francisco Paid Leave Ordinance and focus on really what you need to know as an employer. As you may know, the law went into effect January 1st of this year and phases in to impact larger employers first, but I will leave it up to our experts to dive into all of the details for us. A couple of housekeeping items I wanted to go over before we get started. Our educational webinars are off the record and not for press purposes. So if you're interested in speaking with someone from our team about this topic and are from a member of the press, please feel free to reach out to me and I'd be happy to connect you with the representative on our team. Also, we will be taking questions at the end, so feel free to type your questions in the chat box in the lower left-hand corner of your screen there, and we will take those questions at the end. Lastly, we will also provide a copy of the slide deck for you. So at the end of the presentation, you will receive an email that has a copy of the slide deck attached to it. So we will since we're going over a great deal of information here, we will be sure to send that out to you so that you have a sort of point of reference to look at. And we also have a great deal of resources listed towards the end. So before I kick it over to our speakers, I just wanted to give a quick background about who we are. Small Business Majority is an education and advocacy organization. We celebrated our 10-year anniversary last year. We are national and we have offices throughout the country. We're headquartered here in the Bay Area. As the Northern California Outreach Manager and all of the outreach managers across the country, our role really is just to understand the local landscape of entrepreneurship, of small businesses within our regions. In each of the regions where we have offices, our outreach managers work closely with business organizations, with small business owners to figure out what the top line issues of importance are to small businesses and how can we use that information to ensure that small businesses on a local, statewide, and national front have the resources that they need to continue to grow their businesses. And also it speaks to the policy and the advocacy side and research that we work very closely on. Our work is supported by extensive research, so in order for us to figure out what those top-line issues of importance to small businesses are, we ask them. So we do a great deal of opinion polling, of research to figure out what those issues are and make sure that through our advocacy work that we are truly sort of representing the voice of and the opinions of small business owners. Lastly, our entrepreneurship program brings education and resources on a wide range of areas that relate to growing and running and growing a small business. We offer online and in-person workshops. This session is actually a part of our healthcare and workforce benefits piece of our entrepreneurship program, and it provides information and education on local, statewide, and national workforce policies to make sure that entrepreneurs have the information they need to support their workforce. Now, if you're interested in learning more about our entrepreneurship program, the online and in-person workshops that we host here in San Francisco and the Bay Area, feel free to visit our Small Business Resource portal that has a list of resources and partners that we work with, as well as a running list of all of the events that we have in the region. So that's available at smallbusinessportal.org. All right, now I'm going to go ahead and turn it over to our speakers here. Jenna Jerry with an attorney at Work and Family Program at the Legal Aid at Work, and Ben Weber with the City and County of San Francisco Office of Labor Standards Enforcement. Jenna, go ahead and take it away.
Thank you, Rhea, and good morning, everyone, and thanks for joining today's webinar. As Rhea said, my name is Jenna Gary, and I'm an attorney with Legal Aid at Work in their Work and Family Program. So today I'm going to go over the basics of the new San Francisco Paid Parental Leave Ordinance, including what is required for employers and employees, who is covered by the ordinance, how to apply for the ordinance. Then my colleague Ben is going to talk about how to calculate what is owed to an employee. And then finally we'll talk about how this law interacts with related state and federal laws. So first, just what is the San Francisco Paid Parental Leave Ordinance? As many of you might know, it was passed unanimously by the Board of Supervisors on April 12, 2016. It's the first of its kind in the United States, and it requires employers to supplement an employee's California paid leave benefits such that they'll receive 6 weeks of fully paid leave to bond with a new child. And this includes adoptive and foster children as well. So we're pretty excited about it. And so just briefly of who's covered under it. So not all employers are. There is also a staggered implementation. So currently all employers with at least 50 employees are covered. Starting July 1st, 2017, that will go down to employers with 35 plus employees. And finally, next January 1st, when it's fully implemented, it will cover all employers with at least 20 employees. Now, this threshold number of employees includes all employees worldwide. So it's not just the employees you employ within San Francisco, but if you employ 20 employees worldwide, but maybe only 2 people who actually work within the city and county boundaries, you would still be a covered employer. However, government entities are not covered employers, but nonprofits who employ the threshold number of employees are. So this means employers, like I said, employers located outside of San Francisco, but who have employees in San Francisco are covered. And also when calculating the threshold number of employees, you should count all employees. This means seasonal, permanent, temporary, whether they're full-time or part-time. Those aren't counted in the calculation, but you would not count independent contractors. Now, if you are an employer who has a fluctuating workforce, this means that your workforce goes up and down from week to week. To determine whether you are covered, you must look at the average number of employees in what's known as a PPLO look-back period. So the ordinance defines the PPLO look-back period as the 12 weeks or 3 months prior to the employee's leave. And on the right-hand side is kind of an example of what this looks like. If an employee's first day of paid leave is August 7th, 2018, and at that time the employer only has 19 employees but has a fluctuating workforce where it's going up and down each week, then you don't look at the 19 employees at the time they requested the leave or when the leave would begin, but you go in those 12 weeks or 3 months prior and you take the average. So here, the average number of employees during the look-back period is 21, so the employer is covered by the PPLO and would have to pay the employee the supplemental compensation underneath the ordinance. Now, this is a little bit different for an employee who's going on leave who is a birth mother. So here in California, birth mothers are entitled to up to 4 months of pregnancy disability leave when they're actually disabled by their pregnancy, where this new ordinance covers the bonding time that occurs after the pregnancy disability leave has ended. So you should not count the time the employee is on the pregnancy disability leave in their PPL look-back period time period when calculating whether you have the average number of employees to be a covered employer. So you'll see here on this chart, the employee's pregnancy disability leave period started on May 1st, 2017, while her paid family leave period would not start until July 10th, 2017. So if this is the employee, you would look at the 12 weeks or 3 months prior to May 1st, 2017, not July 10th, 2017, to look at the average number of employees. And again, this is only for if you have a fluctuating workforce. This wouldn't be if you have a stagnant workforce that remains constant throughout the year. All right, so you've determined you're a covered employer. So what does the ordinance require you to do? Well, first, you have to post notice. On the right-hand side of this slide, you'll see the notice that's created by the City and County of San Francisco. It has to be posted at all work sites. You should also, after that, provide employees with a copy of the San Francisco Paid Parental Leave Form. Now, this form is available on the Office of Labor Standards and Enforcement website. It should be given, it's recommended that it's given to all new employees, and then it's required to be given to an employee as soon as they ask about parental leave or tell you that they're expecting a newborn, adopted, or foster child. Now, after you've given them the form, you've given them notice, I should also mention if you do have an employee handbook, you should include information regarding the San Francisco Paid Parental Leave Ordinance in that handbook as well. After you've given all your notice, then you should determine whether the employee who's requesting the leave is eligible for the supplemental compensation underneath the ordinance, and we'll discuss that in the following slides of how to determine if an employee is eligible. If they are eligible, then you should calculate and pay the supplemental compensation, which should be paid on the payday for the next full pay period following the employee's satisfaction of all preconditions. But again, those preconditions will be on slide 10. And finally, just maintain records. You should maintain records of their request, also of any records in determining their eligibility. This includes the San Francisco Paid Parental Leave Form, which when you look at it, you'll see that there's a space for the employer to also sign when the employee provides it to you. And again, all these materials are available on the OLSC website. Okay, so you're a covered employer, and now an employee has come to you saying they want to take some parental leave. How do you know if they're covered? So an employee is covered if they work in San Francisco, that's the geographical boundaries, if they commence to work for the covered employer at least 180 days before their leave period, they work at least 8 hours per week in San Francisco, and at least 40% of their weekly hours in San Francisco as well. And finally, they must apply for and be eligible to receive the state's paid family leave benefits from the Employment Development Department, commonly known as the EDD. Just like government employers are not covered, government employees are also not covered underneath this ordinance. So once you are a covered employee, there's 4 steps to really apply for and receive your benefits underneath this ordinance. First, you have to apply for the state's paid family benefits through the Employment Development Department. Now this can be done online or through a paper application. We do recommend doing it online. It's usually a faster processing time. On the application, there will also be a question asking whether you grant the EDD permission to release your benefit amount information to your employer. We recommend checking that box as well. That will allow the employer to contact EDD if they need to get the weekly benefit amount. Second, the employee must complete the San Francisco Paid Parental Leave Form, which should be provided by the employer. The form is 2-sided, and if you have multiple employers, you do need to complete a form for each employer. The employer should then sign it, provide it to the employer, who should sign it as well, and provide a copy to the employee. With the SF Paid Parental Leave Form, they should also attach their Notice of Computation. Now this is a form the employee receives from the Employment Development Department about 7 to 10 days after they've applied for the benefits. This form, and later on you'll see an example of what this form looks like, will have the employee's weekly benefit amount, which the employer will need to calculate what they owe the employee. Once they've submitted their forms, then if requested by the employer, they should notify the employer when they receive their first paid family leave payment from the state. The employer may also request what's called a notice of payment, or also known as electronic benefit payment notification, which is what you receive from the EDD saying you've actually been paid. And the employee will receive their benefits on a Bank of America debit card. Now there's a detailed step-by-step guide which is available on the OSC website that lays this out pretty clearly. This is just an example you'll see of the San Francisco Paid Parental Leave form. If you just have one employer, you only need to fill out the first page. But if you have multiple employers, you need to fill out both and give a different copy to each employer. And so the second page was where you'll have to list your wages for your multiple employers that you have. So I now want to take a step back and just talk about the state's paid family leave program, since this ordinance is so closely tied to the state's benefit program. So in 2002, California became the first state to offer a paid family leave program. Now this is entirely employee funded, and it's a payroll deduction that comes off of employees' paychecks. So nearly all private employees pay into this. And the only requirement to be entitled to receive paid family leave is that you've paid into the state's disability insurance program within your base period. And I'm going to discuss what that base period is on the next slide. But if you've paid into it, you then are entitled to receive 6 weeks of partial wage replacement while you're either caring for a seriously ill close family member or bonding with a newborn, adopted, or foster child. And again, this ordinance only applies to that second category, bonding claims, and does not apply to when you're taking paid family leave to care for a family member. Currently, the state provides employees with 55% of their weekly wages. That's up to $1,173 per week in 2017. However, this is going to go up in 2018. It is going to be 60% for everyone and then 70% for the lowest income earners. Now both parents, if they've paid into the program, can receive paid family leave at the same time or different time depending on their choice. Paid family leave can also be taken intermittently or all at once, so you wouldn't have to take all 6 weeks at once. You could take 2 weeks here, 4 weeks later. They just have to be taken within the first year of the birth of the child. There also currently is a 1-week waiting period, which means you won't receive benefits for that first week that you are out of work. Rather, you'll start receiving your benefits on the 8th day. And so if an employee wanted to receive all 6 weeks, they would have to be out for 7 weeks. Now, this does not apply to birth mothers transitioning from state disability insurance because they've already served their waiting period when receiving their state disability insurance benefits, so they don't have to serve an additional waiting period. This waiting period will also be eliminated in 2018. So I just wanted to briefly touch on how the EDD calculates an employee's paid family leave benefits. It's not based on the current wages of the employee, but rather it's based on what's known as the employee's base period. Now a base period covers 12 months and is divided into 4 consecutive quarters. The employee's paid family leave benefit amount then will be based on his or her highest quarter of earnings in the base period. So will not always equal 55% of the current normal weekly wages. And you don't count the quarter in which you apply. So if you look at the chart there, you'll see if you apply in February, you don't count that quarter, but they'll actually go back to the prior quarter and do a year prior to that, and that will be the base period. And this will become pretty important when you're calculating the actual supplemental compensation. And so to keep this in mind, as I now turn it over to Ben, who's going to talk about the employee supplemental compensation and how to calculate that.
Thank you, Jenna. Good morning, everyone. My name is Ben Weber, and I work here at the Office of Labor Standards Enforcement. And this morning we're going to talk about supplemental compensation, which, as Jenna mentioned, is sort of layered on top of the California Paid Family Leave Wage Replacement Benefit Program. So the main sort of purpose of the ordinance is to bring the employee to 100% of their normal gross weekly wages. The ordinance caps that benefit at $2,133 in 2017. To help cover their obligation, an employer may, but is not required to, get the employee to agree to use up to 2 weeks of accrued vacation. We'll sort of explain that in a little more detail in the future. The employee does not have to agree, but if the employee disagrees to allow the vacation to be used, then the employer does not have to pay the supplemental compensation. For paid time off plans that do not distinguish between sick and vacation, the employer can still require at their discretion the employee to agree to use up to 2 weeks of PTO, but only in excess of 72 hours of accrued unused PTO, and that is to ensure that the employer complies with the San Francisco Paid Sick Leave Ordinance. In terms of timing of the payment, it has to be paid in full within 30 days of the end of the employee's leave. As Jenna mentioned, the rules state that the employer should make their best effort to pay the employee on the next completed pay period or full pay period after the preconditions have been met. And then finally on this slide, sick leave is not to be used to cover supplemental compensation, and the payment comes from the employer, not from the city and county. A couple of brief terms. The Employment Development Department's weekly benefit amount is very important for the calculation. That's how you can determine what the supplemental compensation is. The next thing that you will need is the employee's normal weekly wages, and that's either the employee's salary the week before the leave, or if there's fluctuation, then it's a calculated average, and we have a slide with an example of that. The notice of computation, which has the weekly benefit amount on it, is sent to the employee and is also hopefully submitted along with the San Francisco Paid Parental Leave Ordinance form. And finally, there's a link here to our website which gives calculation instructions. So this slide, the next slide, is just a snapshot of what the notice of computation looks like, and the red arrow there sort of shows that the weekly benefit amount is $962. The maximum benefit amount is the weekly amount times 6, and the daily amount is the weekly amount divided by 7. EDD pays on a 7-day week. The supplemental compensation will actually be paid that the employer owes the employee will be paid on a 5-day week. And then, as Jenna mentioned, the employer at their discretion can also request an electronic benefits payment notice, which contains the pay periods and the amount of the pay. So this slide here is an example of how to calculate in a fluctuating wage situation for biweekly pay periods what the normal weekly wage is. Again, you'll know if you need to calculate it, generally speaking, an employee who receives tips or bonuses or commissions, or whose hours just simply fluctuate overtime or not, you will then need to basically average the weekly wage. As you can see in this example, we have 6 biweekly pay periods that total $13,200, and that's for 12 weeks. You divide by 12 and you get the $1,100 as the average weekly wage. So for the first calculation example, we have the EDD base period and the normal weekly wage is the same. This will not always be the case because, as Jenna mentioned, the base period that EDD used is about 5 to 18 months in the past, and so it's possible that the employee's normal weekly wage is higher or even potentially lower. In this particular case, the weekly benefit amount from EDD is $550, which is 55% of the $1,000, and so the weekly supplemental compensation that the employer would have to pay is $450 a week, or $2,700. This is just a graphic representation of that. It's a 45 and 55% split between the employer and EDD. For calculation example 2, the base period is still, the EDD base period weekly wage is still $1,000, but the normal weekly wage this time is $1,100. As you can see, after you subtract the EDD weekly benefit, which is 55% of the $1,000, the supplemental compensation in this case is $550, and you multiply it times 6, and that's sort of the total obligation. Here's the graphic representation of that shows sort of a 50-50 split. For calculation example 3, the same as example 2. The only difference here is we wanted to sort of highlight how, if the employer chooses, they can ask an employee to use up to 2 weeks of unused accrued vacation. In this particular case, the employee's 2 weeks of vacation are worth $2,200. So you have the $3,300 that is the obligation. You subtract the $2,200, and then you have the $1,100 left, which is what the employer would pay after the vacation value is sort of spent down. If you wanted to sort of figure that out in a weekly fashion, you would divide the weekly supplemental compensation amount, which is the $550, into the $2,200 vacation value, and so that vacation for this particular employee would cover about 4 weeks of the, or exactly 4 weeks of the supplemental compensation. So this bar chart here sort of shows the sort of where the value comes from. If you sort of look at, so I can try to draw a little yellow here. If you look at the yellow, that 550 portion, or that half of the sort of total wage replacement benefit the employee receives, is coming from the employee's vacation bank. The half on the bottom comes from EDD, and that's consistent throughout the 6 weeks. And then for weeks 5 and 6, you have the employer sort of paying out of pocket the sort of remaining $550 of supplemental compensation that's owed. This pie chart here is sort of the 6 weeks sort of breakdown. So EDD in this case is paying 50%, vacation pays about a third, and the employer sort of pays the remaining amount. A couple of just sort of final notes. As I mentioned earlier, the maximum benefit, which is defined in the ordinance, there's the citation for it, is $2,133 for 2017. If an employer wants to pay more than the maximum because the employee's maximum weekly, or excuse me, gross weekly wage is greater, they are able to do so. The maximum EDD benefit is $1,173. If there's no accrued vacation or paid time off available, the employer still has to pay the full amount of supplemental compensation owed. As mentioned earlier, the employer does not have to request that the employee, or require that the employee agree to use their vacation. That's at the employer's option. You could understand why you might want to, but you don't have to. And then finally, Section 33H.6, as Jenna mentioned earlier, is the sort of documentation requirements. So as pertains to supplemental compensation and noticing your employers, or your employees, excuse me, you definitely want to save your paperwork about how you did the calculations. You also want to make sure that you can run a report from your payroll to demonstrate precisely how much supplemental compensation was paid, so that you can protect yourself from complaints. With that, I will turn it over to Jenna.
Thank you, Ben. So now I just wanted to touch briefly on how this interacts with other federal and state laws that are related, because I think it really puts the ordinance in perspective and can help answer some questions. So I'm sure a lot of you have probably heard of the Family Medical Leave Act, or our version of it here in California called the California Family Rights Act. And this is federal and state law that provides eligible employees with up to 12 weeks of job-protected but unpaid leave to either bond with a new child, care for a family member with a serious health condition, or to care for your own serious health condition. So this is a law that allows employees to take the time off work and be able to return afterwards. While the paid family leave program we discussed prior is just a wage replacement program that allows you to get benefits while you're taking the time off work. There are three pretty big eligibility requirements for an employee to qualify for this time. They've had to be on the job for 1 year. The employer must have 50 plus employees, and the employee must have worked about 1,250 hours in the prior year to their leave. This is a little bit over part-time. Now, if the employee meets those eligibility requirements, they then are entitled to 12 weeks within the first year of the birth of the child to bond with that new child. This can be taken intermittently or all at once, but like paid family leave, has to be completed within the first year of the birth or placement of that child for adoption or foster. Now, for birth mothers, this bonding leave does not start until after they have recovered from pregnancy disability leave. And as I mentioned before, in addition to this 12 weeks of job-protected leave under the FMLA or the California Family Rights Act, California also has a law that provides pregnant women up to 4 months of leave while they're disabled by their pregnancy. And so their bonding time would not start until after they had recovered. And I'm going to go to, there's some slides here that kind of show how this works. So you'll see on this chart, on the top is the wage replacement, and on the bottom is the job protection. You can see they run concurrently. So this is what a non-birth parent's leave would look like if they're eligible for FMLA or CFRA. As you'll see on the bottom there, they get up to 12 weeks of job protected time off, and this includes continued health insurance benefits. And then for 6 of those weeks, they can receive paid family leave and paid parental leave supplemental compensation under the new San Francisco Ordinance. This is how it works for a birth mother who is eligible for FMLA and California Family Rights Act. As you'll see, they get their pregnancy disability leave, which for a normal pregnancy, a woman is considered disabled 4 weeks prior to their due date and about 6 weeks after to recover. So that they get their job protection under pregnancy disability leave. They can receive the state disability insurance benefits, and then once they recovered, if they qualify, they have an additional 12 weeks to bond, and that is when they receive their paid family leave and the paid parental leave supplemental compensation from the employer. And so what if the employee does not qualify for FMLA or CFRA? What are their rights to take the paid family leave? So although the paid parental leave ordinance here in San Francisco does not explicitly require the employer to provide the weeks off to bond with a new child, it does contain very robust anti-retaliation and prohibit retaliating against an employee for exercising any right they have underneath the ordinance. And additionally, if the employer terminates the employee during the leave period or after notifying the employer of their intent to use the paid family leave program, the employer still must pay the supplemental compensation for the entire leave. So if the employee does not qualify for FMLA or CFRA, they don't necessarily have to hold their job, but they would have to provide them with the supplemental compensation underneath the ordinance. And I just wanted to highlight what the anti-retaliation provision looks like within the ordinance. So it states that it's unlawful for an employer to interfere with, restrain, or deny the exercise or attempt to exercise any rights to supplemental compensation. It's also unlawful for them to discharge, threaten, demote, or suspend, or take really any adverse action against an employee for exercising their rights. And if they do take an adverse action, they're within 90 days of filing a complaint alleging a violation, there is a rebuttable presumption that such action was retaliation. So something to be aware of, and I have the site there of where that is in the ordinance if you want to go look at it. Finally, we've gotten a lot of questions about, well, what if I already have an existing paid parental leave policy? Do I have to provide more underneath the ordinance? So it depends, maybe. If your existing plan provides 6 weeks of fully paid parental leave for a 12-month period, that means it can be used in any 12-month period. It's available for any covered employee. It can be integrated with the EDD wage replacement that's fully funded by the employer. And it has to allow the employee to choose to take the leave intermittently or all at once. So as long as your current paid family leave policy complies with this, you don't have to provide anything more underneath the ordinance. And that concludes the presentation for today, and I'm going to throw it back over to Ria.
Great. Thank you, Jenna and Ben, for that wonderful overview and really diving into the components of the PPLO, Paid Parental Leave Ordinance, and also the calculation of it. So it looks like there's a lot of great questions coming in, so I'm just going to take a couple seconds here to sort through some of these questions. Please feel free to type your questions into the chat box here in the lower left-hand corner of your screen. We have about 20 minutes to get through lots of questions, so I'm glad we have ample time here. And then it looks like we are also getting questions regarding the slide deck. Yes, we will make the presentation available to you. I will email it out to the email address that you used to register for this webinar. It will be sent around shortly after the presentation wraps. All right. Now with that, let's jump into the Q&A here. All right. All right, so it looks like some of the questions are very specific, so we'll try to keep the questions or try to make the questions relatable to the group here. Let's see. So the question here is regarding current workforce paid leave policies. So what if I already offer a paid leave program? What should I do to make sure that this complies with the PPLO?
Sure. I guess I can take that one. I mean, the main thing about an existing plan is that it has to provide 6 weeks of full pay. It's actually subsection D under 3300H.4 if you want to review the ordinance. But as long as the employee is getting 6 weeks of fully paid leave for child bonding, new child bonding, whether or not you integrate with EDD or you fully fund it, your plan will be compliant. During the sort of noticing stage, you may want to explain to your employee that you provide that, and discuss with them how you want to handle California paid family leave, which would be in addition to your existing plan. But that's really it. It needs to provide full pay for 6 weeks. And as Jenna mentioned, it needs to allow the same sort of employee discretion about whether or not it's taken contiguously 6 consecutive weeks or it's taken intermittently.
Thank you. Okay. Regarding employees employees who are on construction in San Francisco. So our company is not based in San Francisco, but we hire union employees who are sent to work on construction projects in San Francisco. Are these types of employees reported differently than a full-time employee working in San Francisco? So it sounds like these are construction employees and may not be covered as full-time employees.
Well, the ordinance actually has a specific section about collective bargaining. That's 3300H.9. And quite simply it says if the current collective bargaining agreement was entered into before the effective date of the ordinance, which I believe is May 22nd, or 21st, 2016, and that agreement has not been amended or extended, then they're not covered. But if there's a new agreement signed, or if the old agreement has sort of been, sort of extended, there's current negotiations, then the employee would be covered. And then just the sort of the general response is, save the collective bargaining agreement issue, any type of employee is covered. Not 1099 as Jenna mentioned, because those folks are self-employed, but pretty much any worker that works 8 hours a week, 40% of their time, and has commenced work 180 days before the start of their leave is covered inside the geographic boundaries of San Francisco.
Great, thank you. Is the supplemental pay taxable?
That is what most employers are doing. They're doing their sort of standard withholdings. We're not a tax agency. That is to say, the Office of Labor Standards Enforcement can't sort of give tax guidance. But yes, that's how just about every employer we've spoken with is going to handle it.
Okay, thank you. All right, so question here regarding the posting of the notice. If our corporate office is in Pleasanton, but we have employees in San Francisco, where do we post the notice?
The poster can, oh, sorry, Jen, please, yes.
No, go ahead.
No, that's right, you can.
Okay. Well, the poster should be posted where those employees work. So, I mean, it could be posted in both locations, but you want to make sure it's at least posted where the employees who work in San Francisco are going to see it. So if there's separate offices, it should be at both offices. If there's going to be employees in the Pleasanton who sometimes work in San Francisco and would qualify, then it should be posted in both locations.
Great, thank you. Okay. Now regarding if the employer leaves the organization, so if an employee leaves the employer and applies for paid family leave, are they still eligible to receive the benefit even if the employee is no longer employed?
So they would be eligible to receive paid family leave from the state. That is not tied to your employment at all because it's something the employee has paid for. So they could still get the state benefits, but if they're no longer employed because they themselves voluntarily resigned from the position and weren't fired because they requested the supplemental compensation, they wouldn't be able to collect the San Francisco supplemental compensation from their employer. However, if they had asked their employer for the leave and to get the supplemental compensation and their employer terminated them, then the employer would have to provide them with the supplemental compensation as well.
Great, thank you. Now there are a number of questions coming in just on that. So regarding how PPLO interacts with the California Paid Family Leave Program. So let's see here. All right. Okay. So if an employee is covered by PPLO if they experienced a pregnancy earlier in the year, say February, and have taken paid family leave already, and the ordinance for the employer takes effect in July?
Not if they've taken all of their paid family leave. So if you have taken all 6 weeks already, then you don't currently work for a covered employer, then no. But let's say you've only taken 2 weeks of your paid family leave, and starting July 1st, when your employer is now covered, you want to take those remaining 4 weeks, you then would be entitled to supplemental compensation for those 4 weeks, and therefore could have 4 weeks of fully paid leave. But it won't go retroactive to any leave you took prior to when your employer became covered.
Thank you. All right. Regarding the intermittent time, can the intermittent time be taken in days?
Generally, yes. You can take paid family leave from the state in day increments. The only caveat to that is if you're taking, if you're covered under the FMLA or the California Family Rights Act for that 12 weeks of job protected time, there are certain restrictions on intermittent leave for bonding underneath those laws. And so underneath those laws, your employer could potentially restrict you to 2-week increments. There is a smaller exception to that. So yes, you can take paid family leave in 1-day increments, but you just have to be careful in the interaction with the state and federal law.
Okay, thank you.
Mm-hmm.
All right. Now regarding an employee that, oh gosh, I just lost the question here. Hold on. This chat box here, there's a lot of great questions coming in. Give me just a second to sort through these here. Okay. Okay, so what if an employee uses their PPLO and does not come back after the supplemental compensation is issued?
I guess I'll take that. Yeah, go for it.
Go ahead, Ben. Are you sure?
Sure, I'll do it. So if you look very closely at the San Francisco Paid Parental Leave Ordinance form, basically that form is an agreement by the employee to reimburse the employer if they voluntarily leave within 90 days of the end of their leave. So if an employee does not come back, then the employer can ask the employee to pay the supplemental compensation back.
Yeah, and I would just add to that, just you wouldn't have to pay back your state paid family leave benefits, but you are signing a contract that the employer can seek the supplemental compensation if you fail to return for at least 90 days or voluntarily quit within 90 days.
Okay. All right. If an employee does not want to use their vacation time, their PTO vacation time during the paid family leave, can an employer sort of impose or sort of force them to do so?
Well, no. The employer does not have to pay the supplemental compensation, but the vacation time is the accrued unused vacation is the employee's, shall we say, property. And so if the employee does not agree to allow the employer to use it, then the employee or the employer is not required to pay supplemental compensation, but they can't force it to be used to pay supplemental compensation. If that makes sense. Paragraph 5, again, in 3300H.4 is the language specific to that question in the ordinance.
Great. Thank you. Is there a denial letter or a template that we can use to present to employees if the employee does not allow us to use their PTO hours?
I mean, that would be up to the employer. Many employers have told us that, let's say during the first conversation, where sort of Rule 4 about the sort of informing the employee of California paid family leave and the San Francisco paid parental leave ordinance, if they are going to ask the employee to use up to 2 weeks of vacation or PTO, and remember PTO has the sort of protected 72 hours, but if they are going to ask, the employer may very well want to sort of get a writing from the employee that they are agreeing or not, and that way the employer has a way to sort of say, hey, we asked the employee to agree, and either they agreed or they didn't agree, but here it is before the leave started, just so that everything's clear.
Okay. Okay. Now regarding the supplemental compensation, now looks like a question here is for larger employers. So just to clarify on what is actually being paid. So the San Francisco paid parental leave ordinance requires employers to provide 6 weeks of paid coverage as of January 1st, 2017 for employers of over 50 employees. So that's sort of just a question to what exactly needs to be paid in terms of the number of weeks.
Yes, it's starting January 1st, 2017. All employers with at least 50 employees worldwide are required to provide 6 weeks of paid leave for bonding with a new child for eligible employees. So again, this is bonding leave, which is separate from pregnancy disability leave. And current businesses, that's how the law breaks it out. So if you're a larger business right now who has paid leave policies, you just have to be careful when you have what are generally called maternity leave policies, which provides pregnant women which perhaps with 6 weeks of paid leave, but that paid leave is actually during their disability time for pregnancy and not for bonding, because this is 6 weeks of paid bonding leave. So it's just something to be careful about.
Okay, great. That is helpful. Now, could you speak to, could either of you, maybe Ben, this could be a question for you, Can you speak to the resources available in terms of the notice? Where can this employers get a copy of the notice for the posters that they need to post in their place of business? And also, could you speak to the languages? Is this offered in Spanish, in other languages as well?
Sure. Yeah, the notice is available on our website, which is right there on the slide. And yeah, it's in English, Spanish, Chinese, I believe, and Tagalog on our website as well. And as Jenna mentioned, you definitely want to place the website in any location in San Francisco. And for those employers who maybe have their home office outside of San Francisco, but either have employees that work from home who are covered in San Francisco or have sort of placed employees on job sites in San Francisco, you can send the notice to those employees electronically if you need to, and hopefully you save that just sort of as a record that you did provide the notice. The other thing I just wanted to mention, highlight is Rule 4. Sort of explains a little bit more about the employee notification process. Jenna went through it, but I just wanted to. The rules are available on our website as well. But Rule 4 just says we want you to give the form to an employee when they start, and then also when they either ask about PFL or tell you that they intend to acquire a child through birth, foster, or adoption.
Great, thank you, Ben.
Sure.
Okay. All right, question here. If we have a PTO plan, does that mean we can ask an employee to use 72 hours rather than 80, which is 2 weeks?
No, sorry, I kind of did that point fairly quickly. For PTO plans that do not distinguish between vacation and sick, that is to say there's no way to say which the hours that are currently accrued, whether or not they're for sick or vacation, the employee has the right to protect 72 hours. So if they have, let's say, 152 hours accrued, then there would be 80 hours available at the start of the leave, and the employer, if they so chose, could ask the employee to use those 80 hours. If they only had, let's say, 82 hours accrued, then they could only, the employer that is, could only ask the employee to use 10 hours. So the 72 hours, again, is a San Francisco sick leave ordinance sort of integration with the San Francisco paid parental leave ordinance issue.
Great, thank you. Okay. Now regarding covered employees, so I'm going to put two of these questions together. So if the employer has a home office outside of San Francisco and the employee is an admin and does not work in San Francisco, do they qualify? And then secondly, if an employee works from home in San Francisco, is that employee eligible for SFPPLO?
Yeah, so the key is that you actually work within the geographical boundaries of the city and county of San Francisco. So if you have a home office and you're working in your home office that's located in the San Francisco boundaries, then yes, you would be covered if your employer is otherwise a covered employer. But if your employer is based in San Francisco but your home office is actually outside of the city limits, such that you live in Oakland or another Bay Area, you would not be covered because you're not within the geographical boundaries. You're not working that 8 hours per week and 40% of your weekly hours within the city limits.
Great, that's helpful. Thanks, Jenna.
Mm-hmm.
All right. Now just a question on, again, how it interacts with the California State paid family leave. Does the San Francisco paid family leave run concurrent with the state family leave, or is this in addition to? This is actually a question that we get a lot, so just wanted to sort of reiterate that point.
Yeah, so it's concurrent. So basically, those charts earlier on in the presentation, I think, do a good job of showing how this all works together. But basically, when you're receiving, for each day you're receiving paid family leave, you'd receive your supplemental compensation as well. So again, both the San Francisco Paid Parental Leave Ordinance and the State Paid Family Leave Program are just wage replacement programs, and they work together. So in total, you are getting 6 weeks of fully paid leave. It's just the sources of that money are different. You're getting 55% from the state of California through the funds that you've paid for, and then you're receiving the additional roughly 55%, not the same for everyone, from your employer. And then that would run concurrently if you qualify with your bonding time under the Family Medical Leave Act or the California Family Rights Act.
Okay, great, thank you. Now, if the employee does not qualify for FMLA, does the employer have to pay 100% supplemental compensation?
Yeah, so this again goes to remembering the distinction between wage replacement laws and job protection laws. The paid family leave program, the only requirement to get the state's paid family leave benefits is that you've paid into the state's disability insurance program. And so if you're not eligible for FMLA, you're still most likely eligible for paid family leave, and that's what this ordinance requires. It only requires that you are eligible for and receive the state's paid family leave benefits to be entitled to the supplemental compensation. So even if you don't qualify for FMLA, you would still be entitled to your benefits underneath the ordinance. The only caveat to that is you have to be off of work and suffering a wage loss in order to get the paid family leave benefits. And so you would need the time off from work to get the paid family leave and to get your supplemental compensation. But it's in no way is this ordinance tied to, and your rights under it tied to whether you qualify for FMLA or California Family Rights Act.
Great. Thank you, Jenna. Okay, it looks like we are just at 10:30 now, so we wanted to go ahead and wrap up. There are still questions here in the queue, and it looks like they're still coming in. So what we'll go ahead and do is we will wrap. We'll have some sort of closing remarks here. We'll wrap up, and I will send the questions to our speakers, Jenna and Ben. We'll make sure that your questions are answered, or we connect you with folks that will be able to answer the questions if we can't ourselves. But before we close here, Jenna or Ben, do you have any final remarks?
I would just go ahead, Ben.
Oh, yeah, no final remarks other than to say that, yeah, we're happy to take questions. We have staff here, including myself, that respond to emails and the hotline. We also have the hotline available in different languages, and we have language translation service. So all of our contact information is in the presentation, and we look forward to hearing from you.
Yeah, similarly, I would just say here at Legal Aid at Work, we have a work and family helpline. The number is on the slide there, and we have language capacity in English, Spanish, and Chinese, and other languages if need be, that we're happy to answer any questions you have, generally about the ordinance or just questions regarding state and federal laws regarding leave. We also have resources on our website, and we're working on creating with the LSC some very detailed step-by-step guides for employers and employees. We also have an interactive tool on our website where you can go and see the type of leave you qualify for. So just want to highlight those resources, and thank you, Rhea, for hosting today.
Fantastic. Thank you both. And thank you to both to Jenna Gary at Legal Aid at Work and Ben Weber at the Office of Labor Standards Enforcement, and to both of your organizations for taking the lead here on educating employers. We definitely know at Small Business Majority that when you're busy running your business and sort of thinking about where to spend your time, certainly sitting on a webinar is not usually in the sort of priority level. So we're very happy that you are all able to join us here on this webinar to get this information. Just a couple of key takeaways before we wrap up that I just wanted to sort of drive home here. Please be sure that if you are a covered employer with employees in San Francisco to, as Jenna mentioned, update your employee handbook with your written policies on the ordinance, post a notification, that's a very important point, about the ordinance, determine employees' eligibility and calculate that supplemental compensation, which Ben went over. And of course, as all workforce policies go, please be sure to retain records pertaining to the ordinance and your employees' usage. And if you have any questions as you're navigating through your policies, be sure to consult with your human resources professional or an employment law firm if you do have questions regarding your company's leave policies. If you do not currently have an HR expert to reach out to, there are a number of organizations throughout the city and programs that are here to help you. So feel free to reach out to me and we'll get you plugged in. Lastly, we at Small Business Majority are excited to reveal the results of a new poll that we are releasing tomorrow on small businesses' views on the Family Act. The Family Act would establish a federal paid leave program, which would be funded by modest contributions from employers and employees. So we're excited to reveal those results tomorrow. We have been very active in terms of sort of the policy around paid leave programs in addition to the education. So if you're interested in finding out the results of that report, it will be up on our website tomorrow. We'll also send out a release to our network as well. All right, now with that, we will go ahead and let you get back to the rest of your day and running your business. Thanks again for spending an hour with us. Have a wonderful day, and this will conclude our webinar. Take care. Bye-bye.